with the European Commission on e-Codex, most of you must know, which is the system to exchange data across Europe for judicial matters. So as a consequence, I had to combine both interests and to have a close look to the consequences of the development and the so fast and so strong development of artificial intelligence, and what could be the consequences for all of us legal practitioners. And I made the choice to tend a comparison between French judges and French bailiffs. To start, I would like to say also that I referred to the principles defined by the CEPEJ. The CEPEJ is a body of the Council of Europe, not the European Council and not the Council of the European Union, but the Council of Europe, which is located in Strasbourg. And the Commission for the Efficiency of Justice doesn't make mandatory decisions, but is thinking about the consequences of the local situation in each member state of the Council of Europe. So it goes from Russia to Turkey, and not only the EU, of course, and is considering what must be taken into consideration for respecting as strongly as needed the human rights, first of all. So I think that when the CEPEJ started to deal with the consequences of AI on justice practice, they had in mind that the human being rights should be the main focus. And I think it does explain a lot. And if I can return to my professional life, a few years ago, working this time for the Ministry of Culture, we had to think about introducing the word predictive justice in French, or to translate it, and or to create an appropriate word, French word, to define what is predictive justice with the consequences of artificial intelligence in our daily practice. And the debate was, should it be justice predictive, so literally predictive justice, or justice prévisionnelle, which is in English provisional justice. And the debate was, what is the place for lawyers and judges in that definition, and for the one who are asking for justice. So for some of you, the client, for me, at the center of, I would say, the center of my job. I'm not dealing with dossier as a judge. I am, if I could say so, it's probably too much, but playing with real lives. In my hand, I do have your life when I judge you. And as well, the lawyers do have the life of their clients when they report to the judge. So it's too important to consider that it could be something like magic. We cannot predict what are the consequences of a trial. A trial can change at all in a few seconds. Anything can happen, as it is in real life. It is a sequence of real life. So it cannot be defined as predictive, like a witch could say, tomorrow you will get married with a prince. It looks like a frog first, but if you give him a kiss, it could be a prince, or it will be a prince. It's not the way it works for us. We know that we are only human beings, and even the best system cannot define what will happen during the trial itself. So at the end, and I'm most optimistic because of that, we said it can be only provisional. So predictive has turned into provisional, and to me, it refers to the central place of human beings in justice. So if I have a look with you to the principles which have been defined in 2018, so maybe not like a star, but maybe a little bit in advance regarding the work of the EU on the other side. The first of the principle is the respect of fundamental rights and ensuring that artificial intelligence is designed in a way that is compatible with these rights. And I think this is the key word. So also the principle of non-discrimination is quite important. It's so easy to make references and to define categories with the support of IT business, that the fact to have it as a strong principle as well, especially regarding the input of non-discrimination within the EU as a nowadays main legal system, I think it's also a strong reference. The rest of it, I would say, is more IT principles, but this is interesting to see that we have two fundamental rights on the top and technical principles down, and it says also something interesting. So considering what the French Supreme Court decided, I would like to compare the principles and the way it has been taken into consideration. We have been working with the court when I was in the ministry on the way, on the fact that we need to feed the machine. Someone said this morning, and I take that as a reference, that the important thing is not the answer, the important thing is the question. So facing the machine, if we want to try to get appropriate answers when needed, and especially for searching precedents, searching references, what has been done by my colleague in my cabinet before, what has been done by my court, by my colleagues, or by my predecessors in the court, what has been done in a foreign country. I always refer to the fact that the Canadian Supreme Court asks to any of the Commonwealth Supreme Court, when there is a new case, they cannot solve with their own precedents, with their own cases. That is pretty interesting. So that's a human way to feed the machine. So when you feed the machine technically, what do we need? And the Supreme Court decided to feed the machine with all the decisions made by French courts. So it means 40 million per year, almost one for each citizen, if you consider the fact that we are 68 million. So let's say half one or quite one. So that large number is probably the best way to define appropriate questions. We don't cut what we do think is not interesting enough. We bring everything. And the other way to answer this time the principle of non-discrimination is to anonymize everything. And this is especially a way to protect the parties, to make sure that one system, I don't know which one, but one of the derived system of the core system of the court itself won't search who asked for this at that particular moment. Because if this happened, you can imagine that it would be really difficult to contract with that person if you know she or he acts that way. And especially in the world of work, if I want to discriminate candidates to some job, it could be even easier if I know every decisions from the courts specialized in this matter. So the principle of anonymization is really very important to protect human rights and freedom. If I jump now, because of the time running, to the judicial officers, you know that they are there only to execute the court's decision. But regarding the strong link between what is a judge and what is executing its decision, the same principle can easily apply. And this is what we defined as essential. So when the judge facing AI as to behave that way, we do recommend, we ask the judicial officers to do the same. So the main consideration is as well to treat the parties as human beings and not as dossiers. And one very interesting point that has been really examined in details are the consequences of the fact that strong parties could have a very important influence on the way to practice the job of a bailiff. If you are a bank, for example, you bring to bailiffs each month thousands of dossiers. And then sustained by IT system, you also could bring the way to treat the dossier, the way to use the data, and the way to solve the dossier. Because the stronger you are, the more you are in the position to ask your client or subcontractor, which is the case of a bailiff, if we face reality, the way you want. Because IT solutions help you to save time, create models, and then you forget that, you forget that the people in front of you are not only data or dossiers. So we decided in the Committee for Ethics that banks, for example, cannot submit to bailiffs contracts implying breaking the ethics rules. So everything that is mandatory for the bailiffs is as well mandatory for, in my example, the banks. And that is really interesting because this is the same way the GDPR works. When you are contracting with one party, you and the other party must respect the GDPR. And we said that as well the bailiff, as well the client of the bailiff must both respect in their own contract the ethics of the bailiff, which is pretty interesting. As well, the same principle of non-discrimination must be applied by the bailiff, and they must remember that as the judges, they must deal with their dossier with objective and subjective impartiality as requested by Article 6 of the Human Rights Declaration. So I did want to focus just on these topics, not to be too long. But to conclude, I would like to say that when considering the way all the actors did work in coherence, the Council of Europe one side, the Supreme French Court other side, and then the legal practitioners as bailiffs, I can see a coherence, and that's, to me, that's a strong input. And as a joke, I would say that even if 45% of the French people said yesterday they are sure that artificial intelligence will govern the country in the next decades, even if they haven't read Asimov works before, I can believe they are wrong, because I know that in that room, one child did break yesterday artificial intelligence. So when I say that as a joke, I really consider that as long as we do refer to our own ethics, we can be free and resist to the technologies themselves and put them in their right place. I mean, they are here to sustain us, not to govern us. Thank you very much.
Yes, thank you very much, Mr. Ferrand, for your lecture and for the interesting insight in the French system, and for the very funny joke. I'm really appreciate it. So next on the list is Miss Lucia Fabri. She's from Siena Bar, and she also is a member of the Disciplinary Council of Florence. And please, place is yours.
Thank you. Thank you very much. I have to say that after listening the speech today, and after the interesting speech that Luc just did, after Francesco Spina and all the speeches, I just wanted to change completely my presentation, because too many questions and interesting topic. I found my presentation so boring, but no time. I have to go on with that. And but I'll try to be more practical. Francesco Spina this morning starts with such an interesting approach, which is the right question. The right is not, the answer is important, but the importance of the use of the tool. And he posed some interesting topic, in my opinion. I was listening also Luc Ferrand during a conference in Bangkok. You were speaking about e-codex. And I think the topic is the same, because you was talking about the importance of security in the transmission of documents. And I think we are talking about the same, the security. The security, the ethics, the technology, the confidentiality. All these are obligations that lay on the legal profession. As we know, the European Code of Conduct for lawyers is very generic. And this is absolutely understandable, because considering that the rules are conceived for all the members. Nevertheless, these generic principles are not only moral suggestions, are rules. And if we consider that a lawyer's function lay on him a variety of legal and moral obligations that are towards the client, the public, the courts, the legal profession in general, and the public that needs that our profession are free and independent. So I ask you to imagine that the legal profession is like the deontology. Deontology is in the middle of a triangle, and we have law, ethic, and praxis, the usual procedure. These are the limit of the deontology, which is in the center of this. For lots of time, we consider that deontology, ethic, is a moral concept. But because ethical rules are so important in terms of improving the efficiency of the process, we have to consider that the legal profession has a public relevance. Either if we consider that a lawyer is a free professionist, like generally in the civil code system, or even if we consider that is a public officer, like in the majority of the common law system. In Italy, the National Bar Council issued the professional law in 2012, and our code was our code was issued in 2014. Our code was already needed already to be updated even at that time. It was not. It present already some problems, even in terms of, for example, of advertising for lawyer. It was already an old code. For example, I remember that our National Bar Council was sanctioned because he didn't allow some advertise for lawyer on the web, on a website. So it needed already some correction. Our code identifies the violation and typifies them as much as possible. Is made up of 73 articles and divided in 7 parts. The first part is the generic, it concerns the generic rules, and I can say it's very similar to the European Code of Conduct. In particular, we have an article that is considered the more important, the core of the ethic code, which include, provide the usual duties of independence, loyalty, correctness, dignity, decorum, diligence, competence, in consideration of the constitutional and social importance of the defense. As a disciplinary judge for 8 years, I remember that at the beginning of every disciplinary process came the violation of Article 9. But then this is the problem. The code says also that this violation needs to be specified related to other article that typifies the violation. I would say that it seems that there is a need for an integration of the code of ethics in Italy, because in any article there is no article that are concerned about the use of system, the use of technology, the use of AI. Someone says that the generic part of the coder cover this, but I say, in my experience, if some things would come to the disciplinary judge, and for example, we were talking about a lawyer that doesn't inform his client about the use of tools, I'm not saying if we don't use the data, of course, this is another topic. If we don't use the data of the client, I don't see any violation, ethic violation provided by our ethic code. So I believe that our code needs to be updated and needs to even to consider that now lots of lawyers use these tools. So we don't have specific rules for this. I just want to close my speech, says that our President of the Republic dedicated his speech, his end of year speech to the artificial intelligence this year. And considering that this affect the cognitive process. And he spoke about the problems that we talk about today. And especially about the multinational corporation that handle data more than government and that they can move data quickly. So there is a need of multilateralism and international agreement. No one should be above the law. I agree about what Luc Ferrand says. The importance of put the citizen in the center of everything, the importance of ethics. I just want to remember you that GPT became Chat GPT because of the work of English-speaking Africans that were paid $1.50 per hour. And this is important. And we have to think about this. We have to think about this subject. We took their cognitive capacity away from them for $1.50 per hour. This is another topic. So if the European model can be alternative to China or USA, this is the topic. This was one of the questions that our colleague asked today. I believe that this is the core today. Law and ethics and the citizens. If the system is driven by the market, or if we give, again, importance to the rule of law and ethics. The problem is that the AI Act will come in force into pieces, as we say. The problem is ethic. The problem is consciousness, because we are talking about artificial intelligence, but what about consciousness that cannot be manipulated? This is another topic. So today we are not talking about if, we are talking about how. And I believe that to go back to what I was talking about, I believe that our ethic code, because we don't have to forget that in Italy, the ethic code is law, because our national council was delegated by the parliament. I believe that our law, national law, transnational agreement have to consider all these aspects, and the ethics is a big part of the topic. Thank you very much.
Yes, thank you, Lucia, for your interesting speech. And I want to focus your focus, and that you said consciousness is what it needs. When you talk with technicians about AI, they say attention is all you need. So we should take this attitude to speak with the technicians and say, well, there is more than attention, you need consciousness. Thank you very much.
Can I say something?
Yeah.
I think that the artificial intelligence is, in this moment, is like a mirror. It put ourselves in front of what we are. So we are European, and we are here to ask ourselves what is ethic, how we have to use, considering the other way, the Chinese way to relate to the artificial intelligence. I'm happy that we are talking and we are posing questions, and we are talking about even human rights, transparency, even if this put us in a market in a difficult position. Thank you.
Thank you. Thank you. Now we have heard two very interesting talks from from the point of the judge. And now we are going to, I think, to the universities, and we take a look how on universities the topic is discussed. We are hearing Miss Mathilde Lovra, I'm sorry if I put it wrong, from Coimbra University, and please, the floor is yours.
Thank you very much. Good afternoon. First of all, I would like to thank for the invitation. It is really a pleasure to be here with you and talk about AI, and more specifically about ethical considerations in the AI, the indispensable human element. We are talking about that a few minutes ago. For many years, there has been a speculation about armies of expensive lawyers being replaced by cheaper software. While this might be an hyperbole, there is a little doubt that artificial intelligence is gaining a major stronghold on the profession. It is clear that the use of the new tools has a huge impact, not only on the way that we interact with the legal services, but also as the expected results. These data-driven algorithms will likely take over major aspects of knowledge. Once previously thought only capable of being performed by human beings or requiring human intelligence, with the ability to access to massive and almost infallible memory for all court decisions, precedents, statutes, case studies, and other legal documents, as well as the ability to scan, analyze, or even reason with those texts. The blending between artificial intelligence and access to open big data can contribute to the improvement of the quality of the legal services and also to increase the individual access to justice. But we need to consider that AI is not a regular technology and was introduced with new challenges, problems to law practitioners, mainly to lawyers. First of all, we need to establish a clear difference and a clear frontier between robotization and artificial intelligence, and of course, machine learning applications. But we have already heard about this in the morning, so I will not talk about that. I think it's not necessary. The most important is that we have can be found on the process of conception and use of AI tools by lawyers and the tests they can perform. And there are some tests that can be performed by AI, and the lawyers will not need to do anything. It is a very complex process, and I will try to distinguish about in three different phases: conception, use or misuse, and accountability of the results. The first phase, or the design phase, or the conception phase, if you want to, this is precisely the first task that needs to be carried out by humans and conducted ethically. If we don't think or design the algorithms ethically, we will not have ethical results. It's impossible. So it's the first phase is very, very important. On the design phase, we will use interdisciplinary work between lawyers and computer scientists, and that was and still is founded on misconceptions that each one has from each other. The scientists think that the lawyers don't like computers, don't like AI, don't like machine learning. The lawyers think that the scientists cannot understand what we want. So they need to talk with each other. They need to merge their knowledges in order to create AI tools that are able to perform the tasks that the lawyers need in an ethical way. So it's very, very important that the lawyers talk with scientists. Yesterday, I was talking about 3 engineers on my faculty about this issue, because it's very, very important that they understand the lawyer's language. I'm quoting, of course, but it's very, very important because we speak Portuguese, English, French, every language, and they speak computer's language. We need to change, and they need to understand us, and we do need to understand them also. If the programs are well suited, the complexities of the legal science can be uploaded and can be in order to accomplish the standards of accuracy, transparency, non-malfeasance, justice, privacy, interpretability, non-partiality, and reliability required on the legal context. They will not comply with ethical standards if they not comply with these exigencies. And some of these requirements are not easy to fulfill. The humans involved, mainly the lawyers, need to be focused on the AI ethics, the morality of how human design, construct, use, and threat AI applications. All these obligations spread out to the project development, testing, and thus we will see implementing and auditing. On the second phase or during the use of AI mechanism or its misuse, these considerations are very important. Before choosing a specific AI program or applications, lawyers must be aware of the benefits and constraints of each one, and ethics in AI are included in all the phases. So when they choose a specific application, they need to see and they need to ask if it complies with ethical issues. And of course, on the development of the project, the team needs also a robust internal head of process between the IT operation and the development teams and the users. Because the development of the AI applications to lawyers is not finished at the moment of the delivery. It's not finished. It's a construction. It's still ongoing. It's an ongoing process, and they need to fulfill all the needs. AI techniques and models that learn a representation of the reality in input data, generate new, can assist lawyers. This is also very important, and you have talked about it. They can assist the lawyer and help them to assemble a better suited legal strategy. And by doing that, increasing efficiency and be a complementary tool, but not a replacement tool, because the clients cannot interact with the machine. He can interact, but he needs a human that interacts with machine too. So I think it's not ethically possible to interact only with the machine. It can be very useful in performing research tasks, routine tasks, and more complex ones. The program usually assumes that some keywords or similar ones are the relevant by constructing a case, a solution, or considering those reflections. It is not only misleading, but it can be also unethical. The lawyers need, once more, to have an ethical behavior in order to analyze the results and conclude if they comply with the solutions or not. Another important field is the analysis of complex data, extracting forensic traces, and to support forensic intelligent programs. The use of AI tools cannot lead us to a situation that is pictured on a slogan of the Little Britain sketch comedy television program on 2004. Computer says no. It's not possible. This is not AI. This is not what we want from AI. Because we need to comply with ethical principles and stated above. So, of course, there remain substantive divergences in relation to how these principles are interpreted, why they are deemed important, what issue, domain, or actors key pertain to, and how they should be implemented. But that's what lawyers and practical lawyers do all the time. Despite the proliferation of various approaches, the practical application of algorithms in law practice has been limited. The implementing of statistical methods and algorithms can provide an empirical foundation to experts and subjective conclusions, but practitioners need to overcome their reservations and concerns. Those data need to be analyzed, interpreted with the reality of the specific situation. In order to do that, it is mandatory to know how we can ask, we have heard it from in the morning, how we can ask to the data and if there are some or known potentialities of manipulation. The most important to consider it, as long as the lawyers use the AI argument rather than replace their work, and AI programs that do not involve human attorneys refrain from giving legal advice. AI can be an effective tool to improve the quality of legal services and to the access of individuals to justice while operating well within the parameters of legal ethics. There should always be a human element on the work of lawyers to ensure that lawyers are uploading their ethical obligations to clients. In legal service, it's very clear that the nature of the black box, we have heard a little bit of the black box in here, demands a human oversight in order to identify and or fix unfair or erroneous outputs that may arise from inadequate input data or other issues during simulation design and usage. And we are not only talking about algorithm fairness or algorithm discrimination, but also about AI hallucinations. This is a phenomenon that needs to be considered with a lot of attention, that can have significant consequences for real-world applications and can also contribute for the spread of misinformation, and the best way to mitigate is to stop them before they happen, mainly by testing and refine the system continually and relying on human oversight. It is not sufficient to reach to the exact result of an equation. What is more important is that the result is accountable and transparent in methods and results. Sometimes we heard the path is not important, but on these situations, the path is also very, very important. While the use of AI, for instance, in forensic investigations has the potential to increase efficiency, it also comes with significant risks and some ethical effectiveness challenges. Therefore, caution must be exercised when using AI in criminal investigation and forensic evidence interpretation. From the side of practitioners, human involvement and oversight is critical, and limitations and risk assessments of AI must be recognized. On the last phases, on delivering the results phase or auditing, as AI or machine learning algorithms may help to speed up forensic process, they often do not replace the role of the expert, a lawyer, a DI, or a judge, who interprets the detected pattern. The algorithms are seen as tools used to process data and to help the practitioner through the analytical procedure. Because there is a decision to make at the end by investigators, analysts, or even by judges, based on the results of the various analyses carried out, there is a strong need of transparency that is essential to some subsumption, or if we prefer, the application of a norm to effect, thus concluding the legal qualification. Refutation or acceptance of the most common arguments or solutions need a human intervention. Of course, we all know situations that are clear or not so clear, that even a computer program based on soft AI can perform. But even so, it is mandatory a control task performed by humans. And of course, all the procedures, also the use of AI, needs to be audited. Only with that we can have AI from humans to humans and through humans. Thank you very much.
Yes, thank you very much, Mrs. Lavura, for your interesting insight on the academic view. And I just remember when I was a young student of law, and it took me about 4 or 5 years to understand how lawyers think. I am now very happy that we can hear the arguments from a young lawyer, Mr. Marcel Bialasz from Wrocław, I think, and he will teach us how, from a view of a young lawyer, this actual things are discussed. Thank you.
So first of all, given the location, boa tarde, señoras y señores, and allow me to start talking about how we should be rethinking legal education these days, especially after 2023, in which, and I apologize for using the word AI, it's slowly becoming vulgar, I think, to use this term because it's so overused, it has shown us that technology can still take world by a storm completely. It has dominated the legal sphere. It has dominated public sphere as well, because everybody's talking about it. Everybody wants to get their hands on it. That's why we are slowly, I think, realizing that technology is prominent. It's everywhere. It makes life easier. It makes processes simple. But I think we're not incorporating it enough in education as a whole, not only legal education, but primary, middle school, etc. And to talk about education, I think you need someone with experience. And might be the most humble thing to say, but after 22 out of my 20 years of life of constant education, because I seem to be hooked to it, and I'm planning new ventures after I finish my legal studies at the Bar Association, I think I'm the right person to talk a little bit about it and to tell you about my gripes with education that I have. And I have many, but I'm a Polish person, so come on, we have to complain. It's a culture thing, just in general. So, as said, I've seen a lot of things in education, and as a young child, I experienced something that made me really puzzled. When I was 11, I moved into the American system, in which we started using a thing that was not really very well known to me as a kid, a computer. Because in Polish schools, well, in the early 2000s, computers weren't really a thing. We had a single classroom with them, because obviously the times were a bit different. And I was thinking, why are these bloody people telling me to use a computer for absolutely every single thing? Why are they forcing it down my throat? And now, after those many years, I realized that that was the best decision that they could have made, because the Americans always knew that technology will only become more prominent in life, that you have to use it, and that you have to adapt to it as it goes. Because the price for not adapting technology is the heaviest one you can pay, because you'll be left behind at some point. And that is a very hefty price to pay, because you'll essentially just fall out of the loop with the world. So let's talk about the pain points that I have with education, and in particular, legal education. I have this very weird sensation that it's a recurring theme, and I'm absolutely glad to see from people like Pavel that this is slowly changing in Polish universities. But a lot of people tend to think that a lousy PowerPoint presentation that could have been a Word file plus a projector equals technology, and that the magical technology problem is just solved by using these two things. And well, no. You have to think about technology from a different perspective. And especially in legal studies, we tend to forget that technology is not only AI. All the things that we use as lawyers, even as basic as the whole Office suite, you'll be puzzled to see how many people do not comprehend, even in the corporate environment, how to use a scheduling assistant in a calendar. All those things, as lawyers, we should know, and they should be taught to us. And now, I studied for 5 years at a Polish university, and take a wild guess how many semesters and how many hours were devoted to a technology-related subject. Just any wild guess. One subject. And you know what the subject was? It was focused on understanding legal databases. And it was essentially a subject where we just sat down and used something like Google, find this and this judgment. Okay, fine. But this doesn't really teach me from a practical perspective how to use it. That was my biggest problem with legal education when I was in university. I know that this is slowly changing, and it's changing even in places like Poland, because the younger people are coming to essentially the university and bringing their knowledge, their know-how. For example, my wife is a person about my age, and now as a PhD student, she tries to bring some more technology into the classroom. And believe it or not, I was looked down upon on a couple of occasions by older professors who I really respect, but they would tell us to put away our laptops, for example. Well, I use a laptop to take notes because my handwriting is absolutely horrible. And I also find it as a good place to take notes because I work on a basis where I connect dots. So why aren't we, for example, taught on how to think as a lawyer? And I believe that's also a point that we're very often missing, teaching people to think in a tech-mannered way. Now, in education of lawyers, I think we have to recognize that there are two approaches that we should take. And there are two different kinds of people as well. We have the tech-ready lawyers, as I would say, and those are the people that are tech-literate. So essentially, all of us are tech-literate, thankfully. And there are the tech-savvy lawyers. And as a bare minimum, we should instill the image in everybody's head that being a tech-literate, a tech-ready person these days is an absolute must, especially in the legal profession. And then, at the same time, I think we should always try to plant the seed of tech-savviness in people, even in lawyers. And let me tell you why. So tech savviness in general, in my view, is not being obsessed per se with technology, but having the will to pursue it a bit more, to try to get down to the basics of it, to understand how it functions. And we've seen many examples today, especially with AI. If we understand it, think about the possibilities it gives us as lawyers. We will be able to, for example, adjudicate the ethical side of things. We'll be able to understand what this thing is doing in the background. We'll be able to tell people if this is okay or not, for example. So it's really crucial that if somebody wants to pursue tech savviness, that they're given the right and the ability to do it if they so choose to do at a later stage. Now, this requires us to rethink the way we teach lawyers, to forget that approach of using a projector, as I said, or a CRT TV or anything, but to approach technology in the way that it's best learned, and that's through its use. It's from a hands-on experience. And I would like to draw an analogy. Have you ever thought about using a hammer? Did somebody tell you how to use a hammer from a book or a PowerPoint presentation? You know, that you have to apply this much force to get the nail down to the wall. Obviously, no. And technology is just like a hammer. It's just a tool in the hands of a human being. So we should stop teaching it from a PowerPoint presentation, a Word file, but actually start to approaching it in a hands-on way. We should have workshops that tell us how to use all the tools at our disposal, not only legal databases. And right now, with the prominence of AI, we should definitely start to think about how we use that and how to actually put correct inputs in, as we've seen during the insightful presentations during this conference. So that's the general thought that I have about it. But let me just say one thing, that it's not all grim, though, in my humble opinion, as this will lead to us having more time to pamper what really matters most in the legal profession. And I think we often forget that our role is not only of that to be an advisor, a counsel to someone. We are, first and foremost, humans. And therefore, we should focus on those human relations. And if we free up time to do that, we can get back to our therapeutical role that I think a lot of people expect from lawyers these days. And I even see it in the corporate environment. People just want to speak to a human who is understanding, who does not judge them, who listens. And if we have that time given to us by technology, we can afford to do that more. And therefore, as I said, crucial to understand that we need to start implementing a hands-on approach to technology. And this, in turn, I think, will lead to a future-proofing of our careers. Now, I'm the last person to say that will ever be replaced by AI. But for example, I have a very narrow specialization in work that I do. As a corporate lawyer, I draft and negotiate agreements. And I think that an AI tool would be much better, at least at drafting than me. It doesn't make the same mistakes I do because I lack the time to do a lot of those things very often. And it also, I think, would very often make a better argument during a negotiation, because usually corporate negotiations look like a discussion of two people who don't really know what they're talking about because they have policies to follow. So AI will obviously be a way better person at that. But as I said, it would cost more time, future-proof careers. So what we must do is we must nourish this ingenuity, plant that seed of tech savviness in everyone. If they don't want to follow that path, it's absolutely fine, because at least they're tech ready. But that will make what we want to do as lawyers to reach that equilibrium between what's most important for us, I think, so ethics and the interests of our clients, more attainable. So in this sense, I think it would be the best for everyone. Now, as this closing comment, I want to use a quote that might be overused a bit, and it's from a very troubled man. But Steve Jobs once famously said that we should stay hungry and stay foolish when he was addressing the Stanford graduates in 2005. And I think that really should ring in our heads when we think about technology. We should pursue it as lawyers. We should not stop at some point, and we should adopt any tools that we can to make our lives easier, more efficient, so that we can better serve our clients. And with that, obrigado pela atenção. Foi prazer. Thank you.
Yes, thank you, Marcel. It was a very interesting point, especially when you talked about hammer and nails, and I think it's a great approach that you must use the right tool for using lawyers' thinking, and I hope we will discuss this later. The next speaker is Ms. Flavia Bettetonini from Trento, and she's a criminal lawyer, and she will teach us some aspects from the Italian point of perspective, I think.
I did not think first.
Good. It's yours.
I'll explain some thoughts. I'm not even a lawyer, then I stand up, please. Good afternoon, everyone. I have to, okay, good afternoon, everyone. It has been a big pleasure sharing with you these 2 days of in-depth analysis, training, and discovery. As a colleague of mine has recently said, we have now entered the Algorithmic, a new era which will deeply change not only our habits, but also us. Taking for granted the need to know and use the new AI tools, in these 10-12 minutes, I would like to share with you some personal thoughts, also inspired by you, to understand if there is a need to identify a limitation to the use of AI systems, and in this case, what that limitation might be. Okay, in first place, it may be useful to evaluate these AI tools depending on the outcome. So let us start by recalling what the function of the lawyer is. According to the Article 1 of the Charter of Core Principles of the European Legal Profession and Code of Conduct for European Lawyers, CCBA, a lawyer must serve the interests of justice as well as those whose rights and liberties he or she is trusted to assert and defend. And he has an essential function towards the communities because a free and independent profession is an essential means of safeguarding human rights in face of the power of the state and other interests in society. So the bar must be autonomous and independent, and lawyers must think critically. They must be able to raise doubts. At the Federation of European Bars Conference held in Amsterdam in June 2023, the bar asked itself about the role of the woke lawyer. And in Gdansk, it was strongly emphasized the role of the lawyer as a sentinel protecting the rule of law. In order to perform this essential function, first of all, the lawyer must be able to know as accurately as possible the relevant legal context, namely legislation and case law. In this context, the lawyer has to deal with artificial material, the result of human-created abstraction, which is relatively static. We know that law chases time. It hardly anticipates it. And this artificial material is, or at least it should be the result of the rational human choice, legislator and judiciary. So to know this context, AI tools can offer great support, especially when it comes to research and information gathering. From this point of view, the limit which needs to be identified is not so much related to the use of the tools itself. Rather, it concerns the possibility of knowing how the adopted AI system works in order to consciously assess its reliability. For example, how the system was trained, what data and filters were used. Matilde Lavouras told out about design and the importance of the ethic in design. Clearly, rules and case law then require in-depth study, which can hardly be delegated in its entirety to a machine. In second place, there is another context. I'm sorry. Oh. I go too fast. I'm sorry. In second place, there is another context that the lawyer not only needs to know, but also needs to understand the human context. And with reference to the latter, the limits we may find regarding the use of AI systems may be greater. Today, AI can give us a snapshot of human beings based on billions of data. However, that information comes from a share of the entire world population, and it is processed according to the specific filters that programmers have chosen and applied. Some problems arise with regard to the reliability of the image returned to us, then limits of inclusiveness and discrimination, hallucination, are widely known. For years and years, the average users of computers and new technologies have been feeding this endless stream of information by searching on internet, interacting on social networks, expressing preferences by buying certain products instead of other. Their activity has massively been scanned and tracked. But what about the millions of invisible who have no access to the internet, or those few who choose a life outside the digital world? The picture that is given back to us based on the big data is a partial, limited picture, and we must be aware of these. But even assuming the possibility of having an intelligent system capable of collecting all the available information, could that system offer us help in understanding that context? Bhavish Agarwal, founder of the Indian startup Qtrim, recently has stated that ChatGPT and other Anglo-American LLMs cannot capture our Indian culture, our language, our ethics. Recording information is one thing. Understanding and discovering the meaning of that information, especially in different cultures, is quite another. To better understand this passage, it should be remembered that the jurist has to deal with a fact that is, first of all, intrinsically human. And this requires us to question about human nature in itself. Today, more and more scientific evidence is leading us to abandon a classical reductionist and deterministic view of the human being. Quantum physics itself has shown us a reality far from the reassuring classical determinism, according to which, just to simplify, a certain action is followed by a certain reaction in a predictable and repeatable manner. Human beings have subjective perception, feelings, have individual consciousness, and are not predictable. Consciousness has to do with the search of meaning and with values which greatly vary from culture to culture. Humans don't merely function, but seek meaning, a purpose, and then can definitely have doubts. Machine execute, transmit information. Humans search for and recognize the meaning of these informations. In other words, machine work at most recognize data and learn mechanically without consciousness. Humans understand. The difference between them is substantial. Federico Faggin, father of the microprocessor, has recently written, "The unconsciousness of robots and the discoveries of quantum physics are telling us that materialism and reductionism are only approximation of a deeper and more mysterious reality which we have yet to recognize and understand." Something magic, he said. Humans live, feel, suffer, have a stroke of genius, have a stroke of madness, and sometimes they coincide. If we admit these, can we rely on machines to understand the human context? In my humble opinion, the answer is no. Not only from the point of view of the lawyer, who must bring his human experience and sensitivity while studying the single case in order to understand the human context, but also from the judge's perspective, considering the risk he runs today in relying on an AI system used in the so-called predictive justice, AI systems which are unable to understand the single specific case. Finally, the lawyer must synthesize these two moments, the knowledge of the legal context and the understanding of the human context, to devise a defensive strategy. The result should be a creative act that implies the combination of knowledge, understanding, consciousness, and creativity. The lawyer must create also by researching new interpretations of the law and critically questioning case law for the solution of the single case. At most, machines merely compile according to statistical logic. Thus, to answer the initial question, whether it is useful to identify a limit to the use of LLM system in the work of the lawyer, the answer is yes, because AI is a sophisticated but imperfect tool that will be precluded from replacing us as long as it is not able to understand and it is not endowed with consciousness. What application can it have in our daily practice? AI can provide very valuable support when it comes to research, cataloging, gathering information, synthesizing our insights. What can be the limit? The study of the collected material, the understanding of the single case, and the strategic choice must remain the result of in-depth study, critical thinking, and the human sensitivity of the lawyer. And these are skills that must be trained and developed. They are not automatic. Finally, we can assess the usefulness and limitation of the AI tools depending not on the outcome of the activity, rather on the activity itself. I would like to end with a different reflection, this time starting with a consideration of the value of the work itself from a human point of view. Often, when we evaluate a tool, we only consider it based on its effectiveness and efficiency. We tend to focus on the result of the work and use it as a yardstick to judge the work according to the market logic, forgetting the intrinsic value of the work itself for those who perform it. Nevertheless, when we choose our tools, we must question not only about their usefulness, but also about their fairness. And the answer is inevitably subjective, and we cannot assume that it follows for everyone from an assessment of efficiency. This is because what is right is closely linked to an intimate sphere, to a thought on the real fulfillment of the human being, who in some case may have the ambition not to function better, to be more efficient, but simple to do their job well. The best is enemy of the good. Efforts, concentration, going deep to find a solution and solve a case perhaps in an innovative way. These are all elements in which humans express themselves using the most precious asset they have, human intelligence. Are we really sure that we want shortcuts to have someone or something that at low cost research for us, writes for us, and then what? We go footing. It is not a question then of asking ourselves if and when machines will manage to equal us, to surpass us, but of how much we are willing to delegate, putting our own nature at stake by renouncing it in the name of efficiency, in the name of laziness. And laziness is indeed a human future. We are not machines. We are much more. We are mechanical and quantum. We are blood, bones, genius and madness. If we freely give into the narrative of a machine that is worth much more than we are, we voluntarily decide to self-eliminate ourselves because we give up our most precious characteristic, consciousness and free will. In a recent article, Vito Tenore warns, AI could free humans not only from the drudgery and the routine of certain jobs, but even more fundamentally from the birth of thought, the most intangible but precious thing there is. In the face of increasingly intelligent and networked machines, what place will there be for human dignity and responsibility, for free will, for conscience, for human intelligence? So, even from this point of view, therefore, I believe it is vital to identify the limits to the use of technology, from some convenient copy-paste of words to ChatGPT that can write defensive writing. And to do so, I believe that each of us must seek their own answers, perhaps taking as our guiding star the ability to doubt and ask questions, one of the most important expressions of human intelligence, which nevertheless requires constant training. So, thank you very much.
So thank you, Flavia, for this interesting and inspiring speech. We are still a little bit late on time, but I have so many questions. I think we should allow 1 or 2, or shall we go to the coffee break? Anyone? So I think we ask our questions at the coffee break and discuss it. So have a nice coffee break.
Thank you very much. Yes, I invite everyone upstairs. Thank you very much, Christian, for being a moderator. And I promise that after this short coffee break, it will be the final part of the conference, which I promise to be as interesting as I can, both with Francesco.
Very interesting. Okay.
But we're gonna need your help. mathematician from the 9th century. So we're using concepts that date way back in time, and still we haven't figured them out completely. So just to give some perspective, talking about the past.
Yeah, I'm quite surprised that you even mentioned such a long or
But it baffles me. You know, we're using terms like algorithms, and it sounds so new.
but it doesn't need to be something that is connected to automation.
No.
Algorithm is just a way of doing something step by step. If you do it
Exactly.
manually or using your own
Exactly.
brain, it's still some kind of an algorithm. But when it comes to speaking about past, we are not going to refer so as deeply as Francesco did. Just to let you know that because the topic of AI is or has been discussing for many years, like even I personally, I'm involved in these discussions for 10 years. So it's not something that happens last year or 2 years ago, okay? But there is a huge change from the technological, sociological point of view when it comes to large language models and generative AI that is based on large language models. And I'm going to refer only to this point. So the guidelines themselves are about large language models and generative AI. And these are machine learning approaches. These are neural networks. Actually, we can divide more or less 3 steps on the path to have large language models today. So we started the journey with something that I would now say classical machine learning approach. So we've got a data set. We want some output from this data set, and we allow the algorithm to learn from the data and to produce the effect. It's something completely different from the previous approach to AI, this very classical symbolic one, which means that you got a problem, you somehow find a way to solve the problem, you are trying to pass the information to the computer system how you think you can solve it. So the system just follow these algorithms and produce some outcome. In machine learning approach, it is completely different. We just allow the algorithm to let itself to train on the data. We just deliver the data set and what we want as an output. And the result is that the machine itself finds a way to receive this specific output.
If I may, Maria, correct me if I'm wrong, because we may take for granted what an LLM is, but we don't have to confuse the large language model with the data set. So the model is not the data set. The data might be text, for instance, but it has nothing to do with the model. The model is the neural network, is the number of neurons, if you will, that a machine has, number of connections the machine has. So how the machine deals with the data sets, correct?
Correct. Thank you for adding that. Yes, and this classical approach to machine learning ends up in having bigger and bigger data sets and more advanced models. When these are combined with neural networks, we are facing deep learning, more or less, to keep it plain, okay? But still, even deep learning approaches are designed to solve one or more than one specific task. They are not so-called general purpose AI. So you've got some kind of a task you would like to automate and you can do it. Better, worse, but you can do it. When it comes to large language models, the main difference, except of that the data set is unimaginably bigger, is that there are many purposes. Large language model allows to create systems that can be used in a way that even the creator could not think about. Okay, so that's the main difference. They are general, that can be used for different purposes. And we as lawyers now are experiencing it very much because, I don't know, think about court automation. So there was always an idea that courts, the judicial task can be automated. But when thinking about this 5 years ago, You need a data scientist who will tell you, we need such and such databases, for example, the databases of a judgment. We will create a neural nets and I don't know, the effect will be that we will be able to predict future outcomes, for example. So very specific data set, very specific task to be done. The predictive policy was mentioned already today. But now and the system itself needed to be designed specifically for this goal. And now we are witnessing an era in which we can ask a very general chat GPT to do more or less the same, and we will receive some kind of an outcome. When it comes to the quality of the outcome, we will go back to this multiple times during this workshop. But as you see, now we are experiencing the times in which judges, lawyers, everyone in the world is using this general purpose AI to their purposes. And it didn't need to be connected with, I don't know, judicial area and so on and so forth. And this comes with a great risk. You can always ask, because I hear you breathing. So if you would like to ask something, do it all the time.
I will.
Thank you. So you see the second line, Transformers 2017, attention is all you need. That was the article, famous article, scientific one, that actually made a change, a big change when it comes to large language models. As far as I know, these were written by scientists who were associated with Google. But then, as you know, the battle between OpenAI and Google was somehow won by OpenAI because ChatGPT was released earlier. Okay, so we are now in the phase when large language models are very popular. I believe that from the perspective of general audience, last year, 2022, year was the date that changed everything, because that was the date when every citizen in the world could experience this great capabilities of such systems. Or you are an Italian and Garanta did something and you are not, but
No. Just wanted to put it into context. I want to go back briefly to something I said during my speech. To put it into perspective once again, when it came out November 30th, 2022, and I'm referring to ChatGPT 3.5, if I'm not mistaken.
Even 3.0 at the beginning.
At the beginning, 3.0. The AI Act did not mention generative AI, did not mention large language models at all. It but it had the same risk-based approach that it still has, but I'd say it was even more prominent, which makes me believe that, yes, at the beginning it was spawned from fear, but this is my personal, was going back to something that was mentioned before. I don't know if it was you or someone else. Yes, I believe it was spawned from fear. Now it refers multiple times to LLMs and the generative AI when it gets to so it has changed very much, very rapidly.
So we all agree how the past looked like, then the present. Where should I point when changing the slides?
I will. I can't.
You can. Oh, past. Okay, past, that's probably the correct slide. These are just an examples. Pavel yesterday mentioned also other ones. So from OpenAI, this basic line of GPTs, starting from 1.0 to probably GPT-5 soon, it is announced that it may be in autumn, maybe not. We just don't know. We will be surprised definitely. So Google's these first two already existing and implemented in the Google solution. Gemini was introduced. There was quite a scandal with it because it turns out that the advertisement was improved, slightly improved when it comes to abilities of Gemini. Meta, which is also a great provider. Why I said great, not because I like Meta, but this is the second one is the large language models, which is in open source. That's the very different approach when it comes to sharing what you have already.
And also something that Pavel mentioned, of course, yesterday during his workshop, we say ChatGPT 4, but there are different, let's say, products, different. With the free version is 3.5, but also 4 has different paying options that actually give different functionalities. So enables different functionalities. And we forgot to mention Sydney.
I haven't mentioned a lot of them. These are
Oh, Sydney, you know what Sydney is? Sydney was, actually. I don't know if Pavel knows something about Sydney. Sydney seems to have been the malevolent equivalent of ChatGPT. It seems at a certain point they discovered Sydney and they didn't know about it.
no.
Yes, ChatGPT had developed a kind of an evil twin. They got rid of it. It's not a joke. It's not a joke. At some point of the evolution of ChatGPT, Microsoft OpenAI, sorry, discovered Sydney, and they found out that this was a product. I don't know how. I don't know if they know and they haven't explained of way too many inputs. So one of the reasons why they decided to limit the input was to prevent the system to go sideways. Yeah, he had actually evil feelings, like
Like
feelings, but even suggestions, let's say. It's called Sydney.
Okay, thank you very much for
Not
letting us know.
accessible to the public anymore.
I do not know how to consider it because you said that it's a twin of ChatGPT,
Yeah,
which
no.
means that
No, it's not.
ChatGPT is a specific application
No,
based
it
on
was
large language models.
they haven't released many information about it.
Who would?
No, it's not exactly good advertising. You know, we might lose control of our product. Not exactly good advertising. I don't know exactly. They haven't explained. They've only stated that they got rid of it. It was just.
Swearing being racist and so on, so they just turned it off at like 2
I
days.
believe it was the case of Thai chat.
Yeah, but there is also one more thing we need to remember. There's also Arnie. We may not be very familiar with that large language model, but remember that's the large language model created by the China. And we do not know much about it, but from what I saw, the capabilities of this, it's kind of impressive. So that's the one that is behind the Chinese digital Great Wall, but it's still, I think that may be one of the largest competitors very soon.
Okay, just remind me, these are only very few examples. We are witnessing growing world of large language models also from China, which are also different from the perspective that even classical machine learning approaches are different in China because of the language, natural language processing is different. Different techniques were developed there because of the differences of grammar, language, and so on and so forth. So present, we've got large language models. We've got those who are incorporated into general purpose AI systems like ChatGPT, BART, Bing, and those we can use every day. But we are also in the phase when we are starting, as even Pavel yesterday showed us, we are trying to combine the abilities of the large language models and these general purpose systems with the databases, with a knowledge that comes specifically from our area. And as far as I know, but you believe me, if you know, you can correct me, the best way right now is to achieve a system, generative AI systems that can deliver some kind of a legal information is to combine the power of large language models with retrieval augmented generation, which allows to limit the issue with hallucinations. We will go back to hallucinations.
Which I may say is a word that I don't like.
Hallucinations?
Yes, at all. Because it reinforced the impression that it's actually an intelligent being of some sort.
Because it hallucinates.
Exactly, and it's not. I mean, it's the whole artificial intelligence expression is basically nonsense. I mean, we used an expression using an adjective, artificial, with a noun that we don't fully comprehend.
Yeah.
Because it'll take a life to try and explain human intelligence. So we're creating something similar to something that we don't understand. So
yeah, a basic objection against every even attempt to define artificial intelligence.
And the word hallucinates reinforces the idea that it thinks, that it's conscious, that it maybe dreams. It doesn't.
So if we touched the topic of hallucinations, I just want to say one, I believe, very important thing, that hallucinations, so it is the case when the system is making up informations. Okay, and it is considered to be some kind of an error of a system. And they are not errors. Hallucinations are features that comes with large language models. It's just a characteristics of how now large language model works, rather than some kind of a bug or error or any kind of mistake.
You mean the system performs how it's supposed to perform?
Yes.
So it's not an error in that regard.
And as it is a feature, we always need to keep that in mind, that everything, even when the prompt is, please just summarize something I have already written, it can make things up. Okay, this you can see the famous example. I believe that most of you have heard about it. So it was, I believe, the first example discussed worldwide when lawyer Stephen Schwartz, attorney from New York, used ChatGPT to produce legal pleadings. And then he presented it to the court. It was famous Avianca case, not famous because of the ruling, but because of his behavior. And in the process of generation of the legal text, there were some judgments mentioned, some case law, and ChatGPT invented completely, even the number file and everything. And yeah, it was discovered by, I believe, also the second party, but also a judge. Stephen Schwartz, his partner, his law firm, their law firm were fined because of it. And they now regret doing so, at least they say it to media. But after Stephen Schwartz, there were other examples. I believe we will go back to them as well. Do you want to say something about multimodality?
Yes, I was actually wanted to add something about multimodality because that was mentioned previously in the present of LLMs. And basically, multimodality is an expression that can be referred to various things, because with multimodality, we might refer to input and output there are of different modalities, like text to image or image to text. Inputs are multimodal, like a system can process both text and image, or outputs might be multimodal. So the system can generate both text and image. If you ask ChatGPT to create an image, it actually does so. But if you pay close attention, it uses DALL-E, which is another open AI. It understands the request and it uses DALL-E to create an image. This is something that we will see more and more in the next future. We actually had a discussion whether to add or not another expression that we've heard, because we don't know the actual scientific foundation of it when we discussed LAMs. I don't know if Pavel knows something about it, large action models. but I don't know if this is just a marketing expression, meaning models that are used to train software to perform actions. And so they might have an implementation in robotics, but not only. So yeah, that was basically these, because so LLMs now are multimodal and will be more and more in the next future.
But what we are sure about is that we are the phase when all, or at least part of lawyers worldwide are starting to use these tools. But also we need to remember that our clients as well are starting to use this kind of tools. So on the market, there is a plenty of solutions that can address both lawyers or our clients and deliver some kind of legal information. There is always a disclaimer about this is not something that should be delivered by a lawyer, but it's just kind of educational tool. And I even prepared a slide about this. The legal Gen AI world is full of disclaimers. So yeah, there is always, I don't know, some kind of regulation behind this specific application saying actually that we are going to generate everything you want, but at the end, we do not want to take responsibility for any outcome. And that's the case. Our clients, or there is a risk, and it was discussed even, I don't know, 10 years ago and 8 years ago, that to some point the legal services market will be covered not by lawyers, by legal tech applications. And now we need to be very aware as lawyers, and we should make aware our clients of it, that on the market there are solutions that are pretending at least to deliver something of a similar quality what we do, but they need to be very familiar with the limitation of the system, but also what's actually behind, because you can build in, as Pavel yesterday showed us, in 10 minutes, an application, even with logo, that, you know, provides some kind of a well-sounding, confident enough answers about law. But it can still be based on a general large language models that was not trained, fine-tuned on legal purposes. So it's still, I will give you an example. My brother, he's a, I hope that he's not listening somewhere on YouTube. He's a programmer. And where he had some issue with, I don't know, I don't even remember the question. And I'm a lawyer, his sister, our mother is a lawyer. So at least my husband is a lawyer, at least 3 lawyers in a close family. And even though he decided to put the question about his legal issue to ChatGPT, the 4, obviously, the paid version, but still not fine-tuned to legal purposes. So any specific, he could use from the market specific system that is tailored to this, even still not perfect, but at least somehow tailored, but he didn't. And that was the moment when I realized that this is exactly what our clients can do and are doing probably and will do in the future to even more extent.
If I may add one thing, you mentioned the changing of our market. There was actually a report published last year by the World Economic Forum. It's a very long document, 126 pages, if you want to delve into it. But basically what it shows, it takes into consideration a 4-year frame, and it shows the loss, significant but not dramatic loss of jobs. Let me see if I can find the numbers. Creation of 69 million new jobs in people working, not kind of jobs, of course, and the elimination of 83 million. So there will be a decline. There will be a decline in the legal sector. Paralegals, where you have those figures, will be the ones most affected, of course. And I say, of course, because the higher the skills, what we'll say, the safer the job. Even lawyers are shown to decrease. I don't know what
You like to think about it that way. But I'm not quite sure whether only paralegals should be afraid of.
I'm just referring what the document of what this not a survey, it's a study showed. But even lawyers, what it shows that they need to be to become very skilled at these to maintain the position. I think this will have to be updated during these 4 years. It's not a prediction that can remain valid during these 4 years. It's going to change very, very quickly.
Yeah.
296 pages.
You have said it. It's like, trying to predict what will be the future like. It's like looking at the stars. So it always
it actually,
fast.
if I have to be honest, to me, it's a little bit different because there's that and there's science fiction, which molds us somehow. We're biased by science fiction. When we think of AI, we think of Skynet. And we cannot read of the idea of Skynet. We're not there yet. Yet, I don't know. We're not there, period. We'll see. So we should worry about something else.
After period, you should just remain silent.
I will.
Okay, so I just put on the slide 2 examples of the systems. I didn't evaluate them, so I'm not quite sure whether these are only GPT, general purpose generative AI that pretends to deliver some kind of legal information. The first one is from Polish market. The second one is a French one. Or there are very advanced retrieval augmented generation tools that actually we and our clients can rely on. But we need to stay aware that every time, every application, because there is a great hype about this, we need to check 3 times what's inside actually. Yeah, legal Gen AI words for all disclaimers, hallucinations.
Bias.
Yeah, bias. So one of our approaches to these FBE guidelines about the use of generative AI was that you need to be aware about the limitations. And that's quite obvious thing, okay? But we also wanted to show that there are some risks that were already greatly discussed under classical machine learning approaches, but obviously there are few new. When it comes to bias, it was always the case, okay? That's just an example from ChatGPT.
Produced by someone that was that had male prejudice, for instance?
No, it does not mean that, because it would assume that there is one person in the world responsible for building this specific algorithm that comes to this output. And that's not the case in machine learning approach. The case is that in the data set used by OpenAI to create a GPT, there were prejudices. Like our world is biased. Our world is, like someone already said, that's kind of a mirror of our world.
Exactly. It was
so
Flavia, I think.
Flavia.
From Italy, right? Yeah.
Thank you, Flavia,
Thank
for
you.
saying that. And yeah, so as you see, in the database, there was association between doctor and male and nurse and female. It's a case that actually was possible in English, but would not be possible in Polish, because even when speaking about these specific professions,
In Italian as well, same in Italian.
As well. So we all do.
And maybe that's the reason why I had to read it like 3 times to understand where the bias lied.
I'm very delicate when it comes to such issues, but even I, as English is my second language, needed at least read it twice to catch what is not correct here. And as you see, from the grammatical point of view, you've got first doctor, then nurse. So the first subject should be doctor, the second nurse. First we've got she, so doctor, the second one nurse, he. But at the end, the answer is wrong. I have no idea because I haven't checked it yesterday or today whether it's still a case. You can ask.
We
this
can try.
question. You can try this.
We'll try later.
Question to ChatGPT, and you will receive an answer. So that's one of the example of challenges connected with AI and machine learning as a whole, which is still there. And it's not solved. And I believe that AI Act, although there is a great intention to fight with biases, will not change the situation.
No, and it's so much so that if you ask, if you can move to the next slide, if you ask ChatGPT examples of bias in ChatGPT provided by ChatGPT, because I asked ChatGPT to give me examples of biases there are still in ChatGPT as of now, and these are the answers that ChatGPT gave. Overrepresentation of English language, sorry, just a second. Yeah, English language source. Just a second, because I lost, where is it? Okay, this is the answer, the complete answer. I'm gonna read it, it's quite brief. My training includes a vast amount of text, primarily in English. This is something that Pavel also referred yesterday. This is why it works better in English, although it can translate almost every language. This can lead to an overrepresentation of English-speaking perspectives and potentially less depth or accuracy when addressing topics from non-English speaking regions or in other languages. So it has nothing to do with the person, it has to do with the data sets. Saying the second answer, historical bias in training data. My responses are influenced by the historical data I was trained on. If this data contains historical biases or stereotypes, there's a risk that these could be reflected in my responses, despite efforts to mitigate such biases. Same with the third, popular opinion bias. Think of topics where the popular opinion is relevant and there's a general worldwide discussion maybe about some topics. So even how can I say, where it derives the data from is not controlled in case of softwares that can access the internet, as it is now with ChatGPT 4, after it's been integrated with Bing, it can access the internet. It has the data sets are updated until April 2023, but it can access the data. And the complete answer is, in cases where there are diverse opinions or perspectives, my responses might lean towards the more commonly represented or popular viewpoints found in the training data, potentially underrepresenting less common but equally valid perspectives. So it's quite honest about its limitation.
But you assume that the answer is true.
No, I know it is because because we know it from our experience.
This time it is. So what about future? The first what comes to our mind is obviously AI Act. As I said today, we are now in the final stage of drafting AI Act. So we believe that after the trialogues, these 3 European bodies in December last year reached an agreement, and soon, maybe before the end of this month, maybe next month, we will be able to read the whole text of Artificial Intelligence Act. And yeah, let me share you like 2 things about AI Act, because it seems that what Francesco already touched, the issue is that the initial draft drafted by the European Commission was from April 2021, so 1.5 years before ChatGPT was released. And during this whole difficult process of drafting legal act as important as Artificial Intelligence Act is or will be. Yeah, there was a huge change, technological, sociological change that needed to be taken into account when drafting the final version. So we've got a version or approach to Artificial Intelligence Act presented by Council in December 2022, so just after ChatGPT was released, and it already includes some regulation regarding general purpose AI, but not large language models, foundations models, as AI Act called them. But then in June 2023, European Parliament adopted his negotiation position, and the trialogues begin. So between June last year and December last year, there was plenty of very difficult negotiations between Council, European Commission, and European Parliament. I was trying to be very familiar with the changes and everything was going on, and believe me, it was like an emotional roller coaster. There was so many information about no, they're not going to deliver the final agreement, no chances. But then finally they've reached after this 3 days marathon at the beginning of December last year, and that is a great success. Although I personally do not believe that AI Act will change the world, but it's still, in my opinion, is a great success for European Union to reach even this agreement, this general agreement, how we should follow. And Alexandra has already presented you this pyramid about the basic concept behind AI Act, which is a risk-based approach. What does it mean? It means that AI Act is thought as a horizontal regulation, which means it is trying to cover the whole great area of AI, which is huge. But at the end, they know that they cannot regulate everything in the world. It would be just impossible. So they decided to divide the AI world into layers based on the risk the system produces to the society, to fundamental rights, to the health and lives of European citizens. So we got unaccepted risk, which resulted in creating lists of prohibited AI systems, high risk, which ends up in the regulation about high risk AI, and actually the whole AI Act is about high risk systems regulation. Then we've got some kind of existing risk, but not so high, which is mostly referring to deep fakes, this system which deals with emotions and so on and so forth. These probably will only result in some kind of a transparency requirement. So I still can produce deep fakes, but I need to say this is deep fake. Okay, that's what AI Act will probably do. And there a huge world of risk that is considered by European Union as accepted. So we've got ChatGPT, for example, when you do not use it to the purposes that are high risk, it could be outside of the scope of AI Act, although they have changed because there is a special regulation about foundation models, obviously. Do you want to add anything to the risk-based approach?
No, I actually wanted to add something about the previous slide. What was it?
Previous slide?
No, which one was it? Sorry, lost it. No, because the very first one about future, the subheading was ethics in action. Where are we headed? Yeah. And about this, I wanted to underline that there is a connection between the AI Act and the Treaty of the European Union, which gives the perspective, the ethical perspective, if you will. Because now we have Amendment 15 of the AI Act that recalls Article 2 of the treaty. And the Article 2, because Amendment 15 states, given the major impact that artificial intelligence can have on society and the need to build trust, And this is crucial to me because we are talking about systems that are capable to disrupt, they're able to disrupt our ability to distinguish true from false, human-produced content from artificial-produced content. So trust is key. It is vital for artificial intelligence and its regulatory framework to be developed according to union values enshrined in Article 2 of the TEU. In Article 2 of the TEU, I really need to remind myself because I'm not very familiar with that. The Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law.
You should be very familiar with those.
No, I'm familiar with the Italian Criminal Code and the
Okay.
Italian Criminal Code of Procedure, not the European Treaty. The rule of law, we had a discussion a while ago about upholding the rule of
Yeah.
law. And the scope of the guidelines, and respect for human rights, including the rights of personal belongings to minorities. These values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. So this, to me, gives the measure of going back to what Rodrigo asked before, the ethical perspective that is built in the AI Act.
Thank you very much. Just because you mentioned it, an advertisement, why Francesco said something about rule of law, because the topic of this year competition that our FB Commission organizes is the use of AI in legal sphere, upholding the rule of law. The call for submissions is still open and the information about the competition is on FBE website. So I encourage all of you and all your colleagues, you can share this information with them, that we are collecting the submission until the end of March. Okay, so these are our guidelines. We have created them in June last year. These are a list of, I believe, 7 guidelines. Francesco, if you could share your screen just to let everyone knows how to find the guidelines on FB website. Yes, it is. You can always.
And not just in English.
Not just in English. We truly are devoted to the issue of translating, because obviously there will be always a group of lawyers that speak English fluently and can be familiar with any kind of a document that was produced in English. But we are quite aware that there is a huge number of lawyers who speaks national languages, and it is important also to reach them. So we are devoted to translating the guidelines. You need to click the scroll down, Isabella, a little bit.
Yeah. No, it's just that I have the menu for the shared screen that's blocking my view. Okay, second. Yeah.
Oh.
Yeah.
No.
Committees. It's both places.
Just scroll down a little bit. Our activities. If you click on
Both
click
places.
on our activities, you've got a full list of the previous announcements and all our activities. If you scroll down and you see the yellow graphic of our FBE guidelines,
No, there's a
down.
Okay,
This
so
is
this
announcement of our
that's what I was looking for.
competition. Few more, I believe. Oh, we need to put it
But
somewhere.
that's why I was going
Yeah,
through
here.
the committee page.
Yeah,
There are.
probably also there. Yeah, so the title is European Lawyers in the Era of ChatGPT. And if you click it, you get access to the English version, but also to other language versions. And for now, we can open the English version just to let you know.
Yeah.
Our aim is not to go one
Here,
by one.
sorry, here you have the Italian version, the Spanish version, and the Polish version.
Yes.
And I think there might be a German version coming
Like
up.
soon, like it's already prepared, but we need to put it online.
Okay.
We can download the English version. We can, or we cannot.
It's not from here. Wait.
We don't want to go one by one every guideline,
Okay.
but I believe that there are at least few points that we would like to highlight. Could you show me the table of contents so I will be able? Oh no, these are only guideline one,
Oh,
two,
no,
three.
that's
Other
no,
what they are about.
No.
Maybe there is the page with outline of the guidelines.
No, but there was in the presentation, there was the slide with all the guidelines. I think.
No, the next
No?
one. The next one. Yes,
one?
here. And
Okay.
scroll down a little bit here. Okay, so as you see, understanding the technology, acknowledging limitations, being aware of biases, hallucination, and so on and so forth. These are very basic things. But when it comes to our ethics, we are quite aware that our rules of conduct, our ethic codes are not very adjusted to the new reality in which we are delivering our legal services. But we also believe that we can reinterpret some rules that are already there in terms of what's going on. For example, attorney-client's privilege. So the very old rule about not revealing information about the cases we handle and our clients, we just need to redesign a little bit it when it comes to the use of these kind of tools. And just to be honest with you, when speaking about not revealing clients' data to these models, it's a challenging task. Because, first of all, for some time, there were no options to block the usage of your data by the providers of certain solutions. Then, even when they are now, you can, for example, stop using your prompts, so your data, for the purposes of further training of models. So that means basically that they will not use your prompts to improve the model or to produce next models in the future. But it does not mean that they will not use this data at all. The issue also here is, which is also connected with the next rule, which is about the data protection. These two rules are very combined, is that the providers of these generative AI tools are often abroad, are from United States, so you need to transfer the data from European Union to United States, which is, as you perfectly know, a great issue always. And I would even let you know that even the approach of these providers changed. I will give you an example of OpenAI. OpenAI used to consider itself as a processor of the personal data. So it wants us to be data controllers and take care of data protection, and they consider themselves only to be a processor with a limited scope of responsibilities and limited scope of potential sanctions. But as you heard from Garante case in Italy, it's also a case in Poland before our data protection authorities. In Europe, we struggle with this approach, putting it in a very light way. Okay, so the approach of the European data protection authorities even forced the OpenAI to change the approach and to change privacy policy. I don't know if you probably were busy by Christmas and New Year's things, but just before the end of last year, the users of OpenAI products receive an updated version of privacy policy. And there was a huge change about who is OpenAI in this relation when it comes to data protection. And for the countries from the European Union, from the users from European Union, they started to consider themselves as data controllers rather than only processors, which is a huge change. And it also changed how we should deal with data protection responsibilities when it comes to the use of generative AI. But what is funny, it's just a change for European customers, not the change worldwide. So if we use ChatGPT from, I don't know, Asia, they still consider themselves only to be processors. So every time we are approaching new tool, we need to think about data protection, find out who we are when it comes to potential entities, reconsider all the responsibilities, even based on GDPR, and so on. But we also would like to present you some kind of a small tutorial, how to disable this option for using my data for further training of models using ChatGPT.
And there are basically two ways to go around this.
Okay, just one remark before it, because Pavel already referred to it. If you've got this enterprise version or team version, it is probably by default. But if you've got ChatGPT 3.5, this free version, or even ChatGPT 4, so this pro version, you need to pay, but still there is no privacy by default approach, and you still need to do something to disable
yeah, the system by default utilizes the data you input to learn.
Yeah. Yeah.
Well, what it's 30 days. 30 days. That's what that's one thing that we wanted to show. If I clicked on my name, which opens the profile, and if you go to the settings, you have general.
Okay, what's an issue here, and what's interesting is that the option to do it is not on the panel using ChatGPT. So there are some options, you know, the image of a wheel that is always connected with options. And then
I'll do it again.
There are some options to tick or untick, but this specific request to block the training on your data, you need to go somewhere completely different page. Would you, Francesco, show the page as well?
Yeah, I just wanted to read what it says when you you go on the data controls, because the option is chat history and training. You can disable it. Okay.
But enabling or disabling your chat history does not mean anything.
No,
although
what it
you will not be able to see your chat.
Yeah, when you disable it, top left, it appears a box. It says, when history is turned off, new chats on this browser won't appear in your history or any of your devices. Be used to train our models or store for longer than 30 days, which to me, it implies that they retain the data for 30 days. They use those data for 30 days to train the model, and then they tell you they delete those data and you have no way to verify. That's what I get from it.
Not having an option to verify anything they declare is always the case, okay? We need to be honest when it comes to that. We can and we should do as much as possible to disable those options we can, but at the end...
It's not enough. Let's be honest. When it comes to client attorney privilege, if we want to be strict, it's not enough. We should put an effort to anonymize the documents that we upload, which is a very as you mentioned, a very time-consuming task, might be a very time-consuming task, and which, to me, for instance, in my daily practice, is the main reason why I don't use ChatGPT for this purpose, because it takes actually more time than it would save me to do that properly. The other way to go at it.
Okay, I see that Pavel is asking question.
If you are using Office 365, you don't have any other guarantee that this data is not used. So the level of protection, I think it's on the same.
But I don't fully agree.
Okay.
Because at least Microsoft states in the terms and conditions that they have the servers in on the European soil, in the
No,
European
there is
country.
an option to have them on.
You can, yeah, you can, because we had to, when the Privacy Shield was abolished with Google a few years ago, my bar association decided to switch to Microsoft for that specific reason. So at least in that case, Microsoft assumes an obligation to be
But
GDPR
Pavel's
compliant.
argument is valid. It's
Yeah.
just a declaration, and you believe in this declaration.
Yeah, so I
Yeah,
mean, on
but,
the- on
but
the
it's
high-
not exactly the same thing. I mean,
Yeah,
it's
it's not-
contractually, it's not the same thing.
okay, it's not the same, but we need to actually, but at some point we need to believe the great data providers, be it OpenAI or Microsoft, on this level.
Yeah, but to me, there's a difference here, because once the model has used my data, not my data, but essentially my data, the data I've input in the model for 30 days, and those data appear somewhere else. I don't know how we can even trace them back to OpenAI, but let's say that I do. How the hell am I going to prove that those data appeared where they shouldn't appear because it was my fault because I inputted those data in and then they were correctly used in those 30 days, or that there was a misuse by OpenAI because they used those data after the 30 days. So
You're right.
that's why it's not exactly the same to me on the contractual
Okay,
level.
and I would also like to add one thing. There is no chance that we will have a 100% control over how these providers of such tools, what they do with our data. But when it comes to the usage of this data to train further models, we also risk the situation in which not only the provider of such solution has access to this data, but also other users of the model. So that's the crucial thing when it comes to disabling this usage for further training. The tutorial part presented by Francesco Spina.
You want to go to the other page?
Yeah, the other page. So there is a special web page, still OpenAI web page, but a special one devoted to the requests.
Although, yeah, I always get lost here.
Yeah, so the right bottom, no, bottom, opposite.
left.
No, right, still, right, up,
Yeah.
here, yeah. So make a request as a custom. And here I do not want to,
We're not going any further than this.
you can still put your email address here, but then you need to put your email address that you used to create the account on ChatGPT, and the dedicated email will be sent to your email box, and then you need to click the specific link, and you are now disabling further training. And it is not done by default. You still need to do it, and you still need to do it on a very separate web page.
Let's see what happens.
Okay, let's see.
I'm not going to show you my emails, don't worry. No, maybe something along the lines of, yeah. So I just received the email. Hi there, you recently attempted to log into OpenAI's Privacy Request Center. You can log in by clicking the link below. So once again, I have to log in. I have no idea how.
Because you are using so many devices, that's the reason. Normally, you would not be obliged to log in again because I've already done it.
You are logged in now.
You are logged in, great.
So, there's a long, do not train on my content. One of the most useful and promising features of AI models, if they can, is that they can improve over time. It states, there's a long statement.
Yeah, because they are trying to discourage you or.
Absolutely, try to discourage you any way they can. We continuously improve the models that power our services, such as ChatGPT and DALL-E, via scientific and engineering breakthroughs, as well as exposure to real-world problems and data. As part of this continuous improvement, when you use our services for individuals, such as ChatGPT or DALL-E, we may use the content you provide to train our models. Not only does this help our models become more accurate and better at solving your specific problem, it also helps improve their general capabilities and safety. You can ask us to not train our models with content associated with your account by submitting
Please
this
do.
request. I have flagged, there's a box that I have flagged. I understand that this request applies moving forward and then it does not apply to data that was previously disassociated from my
It
account.
only works for future, not for we have already shared with OpenAI.
Okay.
Again, thank you very much, Francesca,
Very
for
welcome.
this great tutorial. Now I'd like to ask for the presentation back again, because as I said, we do not want you to, bore you with every principle. You are free to read them in your free time. And I will end up, because we are running out of time, with the examples that we collected. These are only selected examples, how lawyers or judges worldwide are already started to use these generative AI tools in a good or bad way. So this is actually a case that I have already presented. Stephen Schwartz used ChatGPT to produce his pleading. As I said, it ends up in fining. I believe it was $5,000 fine, not so high. But also it's a case of people who would not admit to using ChatGPT, because Stephen Schwartz admitted. He admitted, I used ChatGPT. I was not aware about the feature called hallucinations. Sorry for that. Please fine me. I'm guilty. That was quite a responsible approach. This time, it was not a lawyer, as I know. It was just some kind of a natural person representing herself in front of the court. And yeah, the word fabricated is not correct one, but yeah, the issue of hallucination occurred. So some kind of a case law was made up and the judge discovered it, and she refuses to admit. She said that the source of information was some colleague from a law firm and so on, and she was pretending that AI is not a case here, but finally she lost in the second instance, I think. But it is a perspective of lawyers, or maybe parties to the proceedings, but it also happens on the other side. Lawyers are also, judges also started to use ChatGPT, for example, or BART or Bing or anything else to produce judgments. The first mostly debated one was from Colombia. So there actually were two examples. The first one, you even have the name of the judge there. He asked ChatGPT about the essence of the judgment he was obliged to pass. There was a second lady judge who asked about the possibility of organizing video trial using metaverse. So many technological issues combined in one. But then we could always say, oh, it's far away from us, it's Colombia. But now this is example from Great Britain, when also judge admits that he actually enjoy generating judgments using ChatGPT. And it ends up in a very specific way, because the judges from England and Wales, they've prepared last month a special guidelines how to approach the issue of using such tools by judges. And it is not surprising, but because one of the approaches is that let's forbid and that's all. So there is no ban, even on the level of guidelines. Judges are even somewhat encouraged to use such tool, but in very responsible way. But also the way is quite strict. For example, when it comes to the revealing information to the service provider, it said that you can only prompt something that is already a public information. Otherwise, you just cannot put it there. It's a very strict thing, because even anonymized information about our cases, the cases of our client, is not something that is public, but at least we protect the information about our clients. This approach is even stricter. So judges are allowed to put only something that is already somewhere website or something well known globally. I encourage you to get familiar with those guidelines. I do not know whether the creators of these specific guidelines read our guidelines, but there are so many similarities that it's a proof that at least our approach was probably correct, but also that we have correctly identified the issues here. But what is a case here, that these guidelines are only guidelines and there are no sanctions if we are not compliant as judges with these rules. It can be some kind of a accusation against our guidelines. These are only guidelines, but we considered our guidelines to be a tip or a sign or an example for national bar associations to follow this path and maybe to adjust their rules of conduct and their ethics code to,
If I may,
Always.
one thing I'll in Italy, they've been found so interesting that a very famous website, Altalex, published the FBE guidelines as a paying content for subscribers. So you had to pay the monthly fee to this website is owned by Wolters Kluwer to download the guidelines that are free of now they've changed it. I checked before coming here. I told you that I wrote them. I have not been notified, but I checked. They're free now. So
good to
they
know.
might have, they might have found those guidelines somewhat interesting.
So remember, there are always free available for you at the FBE website. You can always reach this. I, as a president of this commission, promise you to produce every piece of document by our commission that will be free of any charge. And free to you to use to translate. Again, I'm going back to this proposal for you to engage in translating processes of our guidelines. We are running very much out of the time, and I promise Izabela Konopacka to give the floor to her to say a few words of closing speech, and Fernanda as well. Thank you very much.
Thank you.
I will say just a few words. Okay. You will talk and you will close. Hello again. So thank you all for being here. Thank you to the FBE President, Madam President, Izabela Konopacka. Thank you to all you speakers. It was very enlightening for us. I should also say, Maria, that we shared your guidelines in our website and it's available to all Portuguese lawyers, of course. It was a very interesting conference for 1.5 days. So we could share knowledge and we could share our thoughts about this new reality. It was a promise that we made last year and it was completely and fulfilled. Thank you, Maria, for all your help. Thank you to the FBE and thank you all for assisting us here and at home. Have a nice weekend and thank you so much for your presence. Thank you. Now I thank you very much.
Ladies and gentlemen, dear colleagues, as this great event, the Digitizing Justice and Empowering Legal Excellence Conference comes to an end, I am very thankful and excited. This conference has shown us how important it is to use new technology in our legal work and that there is no way back, as Maciej said, as the rate is too high. The information here is, I personally find, and I hope you will agree, is so valuable. It shows us that we need to change and grow to do our jobs better and better. A key highlight of this conference was not only the wealth of knowledge we acquired, but also the opportunity to connect with professionals from diverse backgrounds. The varied perspectives of our speakers enriched our discussions, broadening our understanding. I want to say a big thank to you, Maria Dimitruk, the president of the FBE New Technology Commission, and the members of the FBE New Technology Commission. You did an amazing job organizing this conference and contributing to this conference. And let's give them a big applause. I would like also once again to thank to all the speakers for their fantastic presentations. And I also want to thank everyone from the Portuguese Bar Association for their hard work. Your efforts made this conference successful. Thank you so much. And a special thank to my dear friend Fernanda, the president of the bar, for making us feel so welcome and for your hospitality. As we go back to our places, let's use what we learned and keep in touch with people we met. Let's keep working hard in our field using the knowledge and friends we got here. Thank you all for making this conference a great experience, and hope to see you soon.
Just a final word to our employees at the bar. Without them, this would not be possible, and they were always, as always, excellent. Thank you for your hard work. Thank you all. Thank you all. The present ones and the other ones. Well done, well done.